Hello, everybody, and welcome to the revised, refreshed, refined, renewed landscape. That's next week. It's exchange for Monday, 17 August 2026. For those who don't know me, my name is Andrew Peterson. I'm the Chief Executive Officer of the Business Council for Sustainable Development Australia. Now, I'm coming to you today from the land of the Ngunnawal people, which is Canberra, and pay my respects to their elders past and present, and also want to specifically welcome any Aboriginal or Torres Strait Islander peoples today. Before we get into the main discussion with Barbara, Kasia, and Monica, I wanted to surface three pulses that we're now doing through ESG Snapshot. And you may have missed them, you may have seen them, but I just wanted to highlight them, not because they're necessarily recent, but because I think they might actually be quite useful. The first is that the Australian government, as at Friday, has finalised and now endorsed the National Statement on First Nations in Agriculture, Fisheries and Forestry. Now, this statement establishes a nationally agreed direction for stronger First Nations economic participation across those sectors. And for those of you who are involved in our consultation process, it is interesting to see, I think, and helpful that a number of our key recommendations seem to have been absorbed up into, along with the others that made submissions on this. But the big question obviously is now how it becomes part of your normal commercial practice, whether that's in procurement, investment, land and sea partnerships, innovation, ownership, employment and benefit sharing. So with that, I will be, in addition to highlighting it this week, I will then be putting out a short inquiry through Snapshot to the members only in the next few weeks, asking for some feedback on some ideas about a program of work in relation to it, because it is quite significant. The second is, and it's happening, I think, as we speak. In fact, it's probably already kicked off this morning, which is in Ulaanbaatar. Governments have begun the 2-week UNCCD, the UN Convention on Combating Desertification, at COP17. Yes, it's the other COP17 that's happening this year. This one being focused on desertification, land degradation and drought. This particular COP is one of 3 Rio Conventions, for those of you who don't know your history, which sit alongside the Climate COP, which is UNFCCC, and the UN Biodiversity COP Conventions, which is UNCBD, which is also happening, both of which are both happening this year, UNFCCC COP31 and UNCBD COP17. That's happening in Armenia, whereas, as I just said, the UNCCD COP is happening in Mongolia at Ulaanbaatar. Now, it actually has as many parties to it as the other two. In fact, it's got 197 parties registered, of which Australia is a ratified party under the convention, which it did so in 2000. And so we as a country have obligations covering issues including sustainable land management, land degradation, and drought resilience. So what we're going to be watching for you and then reporting over the next 2 weeks over the course of the COP is, in addition to feedback we get from our partner at the World Business Council for Sustainable Development, because they're on the ground at the COP, whether parties are going to in fact break the so-called drought impasse, whether there's going to be some finance on the table to begin moving forward the investable restoration and resilience programs, and whether there is any sense of a post-2030 direction that comes for more measurable and implementation-focused activities. So I appreciate that for some that may only signal a impact upon certain sectors, but can I assure you that in relation to the broader narrative in relation to drought and broader resilience, which feeds in turn into climate adaptation, which has an impact on nature, you can see hopefully some of these so-called pillars now forming bridges across the 3 COPs and some of the corporate activity that will come as a result of that. Now, the third pulse I'll get to in a minute, because that's the one we ran, and we do thank you for your feedback. Let's now jump to Spotlight, which is our news section where a member gives us an insight on something that's been happening in their world. And the short member to member insight we have today is coming to us from Barbara Nebel at thinkstep-anz, who's just told us that Wellington is beautiful today and we're all very envious. So Barbara has very kindly agreed to give us a quick debrief from, I think it's last week's webinar, from early ideas to global standards, the story of LCA. And I've asked Barbara for just 2 or 3 things that she thought were most worthy for members to know and take away. So Barbara, over to you.
Thank you, and thanks for having me. There is so much I could talk about the webinar. We had Jim Farber there. He arguably is the one who coined that term life cycle assessment 30 odd years ago. In 1990 it was. So LCA does go back quite a long time, and he was also the one who wrote the original book, who set the methodology and the framework, which then has been translated into ISO standards, which largely have not changed since. That they do stand the test of time. I had another colleague joining me, and he's more recently been involved in how do the standards develop. And one of the things that is often a criticism on LCA is that there is judgment included. Those standards can be applied to any type of product, to a Christmas tree, to a train, or a building. And that means the standards need to give some sort of flexibility, but they give really strict guidelines on what needs to be described in a certain report. What Jim has also shared is why are there 4 steps to an LCA? And that I thought was particularly interesting because initially it was, let's get an inventory of all the inputs and outputs and all the emissions. Let's define what is a goal and then an inventory. We all know greenhouse gas inventories, and that is where it stops. But in LCA, we go a step further and do an impact assessment. We actually assess what are the environmental impacts. And then there is a 4th step, which is called interpretation. And that is a one battle that he lost because Jim always thought it should be called improvement. And that I think is really important to remember, that we do those studies to actually improve the product. So in LCA, goal and scope, inventory analysis, impact assessment, and then improvement, which is now called interpretation. I also very often you hear people talking about life cycle analysis, and it's actually assessment. And I've asked Jim, why is it assessment and not analysis? And it's exactly that step. It doesn't stop at analyzing all the data. We are making assessments on what could we do differently. So there is that expert assessment coming in and not just calculating, quantifying numbers. And I thought that was a good explanation to really clarify its life cycle assessment. We do have a recording of the webinar, which I will share the link with Andrew. And we had one the week before where 2 of my colleagues and I got together and talked about all sorts of things LCA, and discovered that between the 3 of us, we have done LCAs of condoms, coffins, Christmas tree, cell phones, and probably other things starting with a C. But you can pretty much do an LCA of anything. And I will send through a link to that blog as well.
Oh, I need to draw a veil across that one very quickly. Oh my goodness. Oh, I see I've gone red. Why can't can't you tell? Thank you for that. That was most enlightening. The recording, yes, we'll put that into Snapshot. So thank you for that. And then we'll put it up onto the database as well, so that anybody can then access it into the future. If anybody has any questions, Barbara, would you like to put your email address in the chat and anybody
Absolutely.
can directly contact you for further conversation and consultation should that be necessary. Does anybody have any questions before we move on to the next section on what Barbara shared with us? And can you put your virtual hand up because I can't see you otherwise? I've only got 9 on my screen and I feel like the Brady Bunch at the moment. And for some reason, I've suddenly become Mike Brady. Yeah. No questions? I'll just check chat because I just noticed something in there, which was Barbara's email address. Thank you so much. All right. Excellent. So let us therefore thank Barbara and move on to the news section we're calling Focus, which in this particular case is being kicked off by a new pulse, which we put out only this morning. And as at 10 o'clock, we'd had 11 responses. So thank you for those who were able to. I haven't checked it since then. But the question in the pulse was, because it's framed around the two speakers that we now have, what most puts organisational trust at risk today? And as I say, before the actual session, we asked that question: what's putting organisational trust at risk? We had the 11 responses, and I'm here to tell you that weak governance and accountability was the strongest response by far, followed by claims that outpace action, coming a reasonably close second, which was interesting. Now, together, those two answers actually accounted for 9 of the 11 responses, so just over 81%. And we do thank both BCSDA members and also subscribers to the snapshot for actually contributing. So, not going to lie here, it's not a scientific survey by any stretch of the imagination, but it is an interesting and small directional pulse that gives a useful starting point for today's discussion. What I thought was interesting about it and what caught my eye is the stronger signal is less about a particular technology or partnership, which was one of the questions or potential answers, but more about the underlying discipline of governance, accountability, and credible action that we are obviously seeing rattle through both government, corporate, and community right at this moment. So I thought it was a useful lens for and a context for now our two focus perspectives today, first being the controls that organisations need around generative AI, and then the really interesting one from Monica at the University of Queensland Business School around choices that organisations make about partnerships that carry their name and reputation. But let's jump and welcome in and invite her to turn on her microphone, Kasia Dziadosz-Findlay. Hopefully I got that right, Kasia.
That was very good. Thank you, Andrew.
Thank you. I did practice and I actually
appreciate that.
reached out to Graz van Egmond, who, being Polish, assured me that I got my pronunciation. But I think she was just being kind. But anyway.
No, that was very good.
Kasia is from Gilbert and Tobin and is our first speaker today. She's the special counsel at Gilbert and Tobin's Disputes and Investigations team. So be careful what you ask. I asked Kasia to join us after she and her Gilbert and Tobin colleagues had actually published a really interesting thought leadership piece titled AI in the Boardroom and the Practical Guidance for Boards and Directors, looking at how boards are already using AI or not, the legal and evidentiary risks around prompts, and we all know what I mean by that, as well as the outputs and the chat records, and therefore the practical governance controls that directors should be putting in place. So a big welcome to you, Kasia. Very much looking forward to hearing your thoughts in relation to that. Over to you.
Thank you, Andrew, and thank you everyone for having me. So what Andrew touched on earlier, I think, is a really good intro. So the governance piece, I think there is, as no doubt a lot of people have read and seen, there's a governance gap. ASIC and APRA for some time, the regulators have identified this after taking surveys of various businesses. So essentially the view from the regulators, and no doubt what some people are saying, is that AI adoption is quicker than AI governance. So a lot of entities don't have the right policies in place or inventory of AI platforms, haven't really thought about those sort of things. And the difficulty is that sort of opens Pandora's box to risks. And one of those is the sort of practical thing that Andrew mentioned in terms of the evidentiary trail. And I think it's a really difficult area because it is something new, but I think there are some practical tips that we can discuss. And just in setting the scene before I come to those, it's also difficult because, as we know, the government has sort of changed its views on what it wants to do in terms of legislating for AI, which is difficult because it is just such a broad and complex area. So as we know, last month, the government decided on the AI office. Its purview is yet to be sort of seen and the lines are not quite drawn. But I think the difficult thing for directors, boards and companies is this is sort of a shifting landscape. And so just on the evidentiary trail, so I think the way I look at it as a litigator who's been doing this for a while is people should think about their records in terms of chat or any sort of AI platform inputs and outputs and chats as potential evidence that could be used against them. And I don't mean that to scare people, but it is sort of what we're starting to see. There's been a couple of US cases already and in a very recent Australian case where people have used like large language models in particular for strategic advice or, any sort of things like that, mostly strategic advice in this area. And that has been used against them, so to speak, as evidence at trial. So some of those are director sort of instances where rather than a director going to a lawyer to get advice, they've sort of asked ChatGPT for strategic advice that has in one way or another fallen into the court's hands and been used against them. In the US case, the director actually tried to delete the evidence, so delete the log, which obviously hampers your credibility. So I think that the key things falling out of those cases are knowing that those records could be used against someone. Not saying that anyone would be using chat in that sort of way, but that has been used as sort of pre-contextual evidence. As I said, obviously deletion is an issue which will damage credibility, but poor retention practices is another one. And I think as well, a broader issue, which is probably something we can't get into today, is that executives and directors and boards are relying on ChatGPT or similar platforms without exercising their own judgment is a really big risk area. ASIC has made clear that existing laws apply to directors' duties under the Corporations Act. It's technology neutral. While there might be some new laws coming in due course, those laws do apply now, and that's a really important thing for people to be aware of. And so one quite technical point in terms of the evidentiary trail is that it really does depend on what platform you're using and what you're using it for. So the key takeaways I would give people are making sure you have a secure platform. So it's treated confidentiality. So it's not use your information you give it and the output can't be used by others. And that's a technical point because I think a lot of people don't understand the difference between like open and closed platforms. ChatGPT, for example, is generally an open one. So, for example, some information you give it might be accessible by the provider or others, and also used to train the model. So it's not strictly confidential. So two things, you should be putting confidential or personal information into those platforms. And two, the information it spits out is not necessarily confidential. As a lawyer, that's a key element of protecting information. Some people might be aware of the term, legal professional privilege. It's, if Andrew asked me for advice and he emailed me, that would be a confidential communication and it'd be protected by privilege. Obviously, when you're asking ChatGPT for legal advice, it's not true legal advice and it won't be protected. So I think that's one really key takeaway that people should be aware of. And I think there are ways to protect that information, but it's more technical than we have time for today. But again, yeah, the key takeaway is thinking about are the chat GPT or other AI platform records I'm creating, are they protected? Am I using information that, might be breaching confidentiality or the Privacy Act? And is there a risk that I'm creating a record I don't want? I think a lot of people are using it for efficiency as well. Boards using it for preparing board packs or recording minutes, transcribing things. Again, that's sort of another record that is being created that people just need to think about. So I think it's sort of understanding what platforms you're using, sanctioning them within the business so people aren't, using an open platform for something confidential or sensitive, and understanding what records are going to be kept. And Andrew and I had a quick conversation earlier today about, whether I'm starting to see those documents be subpoenaed and those sort of things. Not yet, but I expect very soon. I think the regulators will start asking for AI records as part of their investigations. I think plaintiff law firms will start asking for those in discovery. I think it will be something that people, as a matter of course, will start asking for. And so I think, again, just to summarize, the key things are people understanding what platforms they use, so the inventory, and telling people within the business what they're allowed to use and what they shouldn't be using, understanding and managing records of those. And I think as well for particularly bigger entities, having sort of AI literacy at the directorship level. So it is, I think that's a really difficult thing. Everyone's sort of using AI platforms, but I'm not sure there is someone within the business who necessarily understands how those things work. And, we all see the sales pitch and from these, whether it's LinkedIn or you've been approached by an AI company and they've got these beautiful sales pitch and go, yep, that sounds good. We're going to save time. We're going to save money. But do you understand where that information goes and how it's used by others, including the provider? So doing that sort of due diligence up front. And I think putting that governance hat on early on before you do anything and onboard someone, I think that's the critical things.
Okay, so my first reaction is, so I can't call my AI agent Kasia to give me legal advice.
Correct.
Through
You could
AI.
call it me, but it wouldn't be true legal advice, which is the difficult thing.
And I don't say that flippantly because I think that would be something that somebody might try to get.
And look, it could give you a really good steer, but it would never be legal advice. And I mean that in a way that you could rely on it as a director. And I mean that in terms of, the obligations under the Corporations Act and those sort of things. It's not a reliable source at this stage. We might, things are moving quickly. We might get to a stage where there is something that you can rely on. And I think it's a good steer, but it wouldn't be legal advice that you can rely on in terms of director's duties. And as I mentioned earlier, it wouldn't be protected by privilege. So your conversations, your chat logs, your output would be something conceivably that's a regulator or a third party could ask for in a dispute context.
Could be accessed. Happy for anybody to ask a question, but I'll ask this one. I had a formal one, but in hearing you, I thought, oh, this is a very interesting issue when it comes to the concerns that companies have about accusations of greenwashing and the circumstances in which, say, internally, the sustainability teams and or the product teams look at a particular product or service or technology that they want to put forward, and they go and make search through AI, not necessarily to validate, but to use that as a test point for the question of credibility and in turn avoiding greenwashing. What would be the implications of that kind of assessment where down the line the company was accused of being was greenwashing?
Yeah, so I think the court's view, as far as I've seen so far, is that AI is not any type of expert that you can rely upon. The safest course, I think, if you're using it to test something, whether it's drafting or testing a fact, is to look at the thought process and the underlying documents or reasoning of the AI platform and sort of verify that yourself. So
yeah.
So I think you would have to ask it for what documents it relied upon, what assumptions it made, what facts it looked at, and then look at those individually to make sure that you agree. Or almost like the way you might treat, someone below you at work, like a subordinate or a junior, or someone who's helping you, to sort of stress test that idea rather than simply rely on it. I think that is a view that the court would take. There has been one case where I think they were directors, but they used the ChatGPT for advice on how to essentially get rid of someone, and it applied the wrong law. It saw it as a HR employment type case rather than a Corporations Act dispute. So obviously people relied on it without looking under the hood of the underlying material. So I think it's a starting point when you have a blank page, but I think you need to verify each point. And if you're using it for building out marketing material or statements like that, it might over-egg what you're trying to say, and then you're in the greenwashing territory. Or there's actually something now called AI washing, which is sort of similar. It's sort of this overstatement of ability. So I said Pandora's box. So you have to be able to verify. So if I came to you and I said, well, how do you back up that statement? You would need to have that. And I don't think if a ChatGPT output would be enough evidence.
Yeah, right. Okay. Oh, that poses so many questions in my head. But we have a question in the chat from Nayan Das. Thank you, Nayan. Hi, Kasia. Is there any case study recently where court regulators sought for AI records? And if so, how long can they go back? Sorry if there's nothing at the moment, but I can see where this is going. Retention policy will be a key component to this piece.
Absolutely agree. And that's why I think it's so integral that people do their due diligence on the platforms before they get them and understand where records are kept and how they should be kept. Because I think it's also not an answer to someone to say, oh, we use this platform, but we don't keep the records. I don't think that will be looked at fondly by regulators or courts, especially when you're trying to verify a fact and where something came from. It's sort of a lot of these platforms operate as sort of a black box, and opacity is where the risk is.
That's really good.
There has been some cases, but the judgments themselves don't disclose how those records came to be evidence. It seems that my sense is that it was referred to by a witness in a statement or an affidavit. So their own personal testimony, so to speak, to the court, but there wasn't any mention of, was it a subpoena, was it discovery or something like that. But I absolutely think that's where this will go, and retention policies will be important. And having obviously policies in place feeds into other obligations that directors and companies have. So it fits into the whole governance piece, I think. So it's really important to have that and make sure everyone understands that.
Very much so. So thank you for that, and thank you, Nayan, for the question. Does anybody else have a question if they'd like to come off mute? Rob, I think, just did. There we go. So Rob actually asked a question in the chat. If AI was used as the basis of a claim, for example, a carbon claim, what is the difference between AI and a third party? I'm assuming that's consultant, good spelling. E.g., would a court accept the consultant's advice as stronger than AI? Oh, challenging.
Yeah, look, that's right. The court's view seems to be, again, there's not a huge amount of case law, especially in Australia at the moment, but the court's view is that humans are different from AI, even though we might think AI is more accurate sometimes. And that, directors under the Corporations Act, for example, you can, in certain circumstances, rely on expert advice. But I don't think the court would think an AI platform is an expert in that sense, who you can rely upon. And I think the courts in particular will be very steadfast in maintaining the human aspect of all of this. So it seems a bit strange when you might think, well, AI, if you ask it a question, it might be more reliable on a statistical basis than a human. But I think the courts won't look at it that way. I think we'll stick to human experts and third party consultants over AI. But again, I think as long as there's a human element in there to verify what the output is, I think that will be acceptable in most cases. But it is that someone is putting their mind to this and looking at it.
So let me just be agent provocateur to that answer.
Mm-hmm.
How is it any different though if the finance director using a formula within an Excel spreadsheet says, well, this is the financial circumstances of this company based on the the formula that's been adopted and has been accepted by the board as to the way in which this company will operate. I can think of, and I'm looking at one of those particular consultants that would have an algorithm or a Python code or some coding and would say, well, underlying the answer that's given by AI is the coding that I, as a human, have been working on with others to develop, and therefore I find it credible. So I'm
I
going to
think
lob
that's
that back to you and say, what
an
does that mean?
excellent question. And I think the answer is that the real risk with AI, and obviously the difficulty is that AI and even Gen AI encompasses so many different platforms and uses.
Yeah.
But if we're talking about ChatGPT, for example, the inherent risk is hallucination.
Yes.
So
Yeah.
it's not it is a technology, but it's not as reliable as Excel. I would be surprised if anyone on this call could tell me where the Excel formula has miscarried. An Excel formula they've used it every day has miscarried, but by nature of Excel, not human error, because I'm not very good at Excel. But I think that's the real difference. I no doubt we've all had many occasions where ChatGPT or whatever it is has hallucinated and made something up, and there's a real risk because it is so fluent and so articulate. It sounds right. And so I think some people are led down the garden path that, oh, this is reliable. That sounds better than I could have said myself, but the underlying fact is wrong. So I think that's the real difference. We're not at a stage where it is reliable. And again, sort of using ChatGPT, not to single that out, but I think it's the most popular at the moment. It is not incredibly reliable, and that may well change, and no doubt it will. Who knows? That could be a month down the line, but I think that's the critical difference, the hallucination aspect.
Get ready for the next version. Thank you. Any other follow-up questions with Kasia? I see no one with a virtual hand up nor a question in chat. So for a moment, Kasia, could you put your email address into chat? If anybody would like to directly converse, please do so. And as always, we thank Gilbert and Tobin for their time in coming and talking to us on those really important thought leadership pieces that they put out, which I circulate on a regular basis to key members and also now through ESG Snapshot. So that's one conversation about trust, right? Let's now move to another, and this is really quite out of left field, and I'm welcoming Monica in particular to this conversation because, as is always, the University of Queensland Business School come up with these amazing pieces of thought leadership that are very tangential, I find, and they just blow my mind every time I read them. And in this case, Monica did one quite recently about, well, I'm not going to tell you too much about what she said, but she is the Associate Professor at the University of Queensland Business School, who you all know is, along with Gilbert and Tobin, a member of our organisation. And I asked Monica to come and join us after she published the quote, "What FIFA World Cup athletes can teach businesses about building powerful brands." And now I'm assuming that does not include the CEO of FIFA, because that's a whole other conversation, but it's actually relevant to this one. exploring what partnerships and sponsorships tell us about trust, credibility, genuine alignment, and long-term brand value, which is highly relevant to corporates because having read a number of your reports, members, I can look at and understand where you talk about partnerships and how they're valuable, but do they create a form of trust for both you and the organisation and therefore the enterprise that you're trying to support there? So with that, Monica does have a few slides and I'm going to make sure that I hand over to her the share rights. There's the share settings. Anyone can share. What is it? Windows can share, scale to fit, enter and full screen, and others share, maintain the current size. Yes. So I think you have that right, Monica. Just feel free to test it. Oh, hang on. Anyone can. There we go. So over to you and look forward to hearing from you and welcome.
Thank you, Andrew, for that very kind introduction. And I'm just trying to, yes, so I think I can see the share and I'm going to share a couple of slides with you and I hope you can all see it now. Is that okay? Awesome. All right. So I'm just going to talk for about 8-9 minutes, but happy for anyone to jump in and ask questions. And so thank you very much for Andrew and for BCSD Australia's kind invitation. It's really a pleasure to be here. So I've been teaching and research on sponsorship for 20 years, and sponsorship has become an important tool for building brands, engaging stakeholders, and communicating organizational values. Many organizations invest considerable resources in sponsorship, but securing sponsorship rights is really just part of the game. The bigger challenge is creating partnerships that people understand, believe, and remember. So whether you are managing sponsorships, evaluating partnerships, or building a brand at the moment, I think 3 concepts are particularly relevant and important, and I'm going to explore each of them today. And these are fit, authenticity, and portfolio coherence. As you can see on the diagram here, the fit, put it simply, is the perceived compatibility between a sponsor and the property it sponsors. Sometimes that connection is obvious. Powerade sponsoring a marathon feels like a nature fit because both are linked to hydration, endurance, and performance. But fit doesn't always come from the product itself. Think about Target sponsoring Children's Festival. The connection is less about retail and more about families, fun, and community. In other words, fit can come from different sources: function, shared values, purpose, or image. So why does fit matter? The answer comes down to how our brains work. We don't usually, sorry, I think I just jumped ahead, sorry. So the answer comes down to how our brains work. We don't store information in our heads as isolated facts. Knowledge is organized into a network of associations. When we see something, related ideas are automatically activated in our mind. So when I see Powerade at a marathon, Powerade brings to mind hydration and performance. A marathon brings to mind endurance, running, and achievement. Those associations overlap. And that's when our brains essentially tells us, aha, that makes sense. So this automatic connection is important because sponsorship isn't usually something that consumers are paying close attention to. If I'm watching football, I'm watching the football. If I'm at a concert, I'm there for the music. And if I'm running a marathon by kilometer 35, I can assure you that sponsorship fit is fairly low on my priority list. So because sponsorship is often processed in the background, partnerships that make sense are easier for people to process, to understand, easier for people to remember and to learn from. And when that happens, some of the positive image or associations that people have about the event, the athletes, or a charity can transfer to the sponsor. This is one of the key ways sponsorships helps brand to build brand image. But does that mean the highest possible fit is always the best? Not necessarily. Sometimes a slightly unexpected partnership can be powerful because surprise captures attention. The catch is that consumers need to be able to resolve that mismatch. Imagine a pet care brand sponsoring the Paralympic Games. At first glance, the connection isn't obvious, right? But if the sponsor explains how animals support physical rehabilitation, independence, and mental well-being, suddenly the partnership becomes meaningful. It makes sense to people. This process is called articulation. In marketing terms, it simply means telling the story that helps consumers understand why the partnership makes sense through various marketing communications. And when people successfully resolve that initial incongruity, partnership can actually become more memorable. So if the fit isn't obvious, don't leave consumers to figure it out themselves. Help them to make the connection. So we have been talking about characteristics of two entities and how they fit. But in practice, some partnerships may have excellent fit, but still feel overly commercial or opportunistic. That is because fit and authenticity are different concepts, and they essentially ask different questions. Fit asks the question, do these two entities belong together? Do they have shared commonalities? Authenticity asks the question, do I, as an audience or as a sports fan, believe this relationship? And that second question is becoming increasingly important because consumers today are much more sophisticated and more skeptical about commercial partnerships. The tennis great Roger Federer provides a nice example. For many years, Federer had a very long relationship with Swiss coffee machine brand Jura. Somehow, Federer standing in a beautiful kitchen, making an espresso from a beautifully engineered Swiss coffee machine feels entirely plausible. There is a coherent story there. Precision, quality, longevity, and perhaps a sense of Swissness, right? So these two entities not only fit together on various dimensions, it is also believable to see Federer using that coffee machine. Now imagine Federer walking onto center court carrying a bucket of fried chicken. Our reaction might be slightly different. Roger, do you actually eat that? Are you for real? Or even perhaps more importantly, we question their motives. Are they paying you an extraordinary amount of money to do this? So what's interesting is that you could probably identify several points of fit, right? Both the fast food company and Federer, both are global brands. They are household names. They are associated with families and highly successful in their respective sectors. Yet the partnership will still feel less believable. And this is because consumers aren't simply evaluating the sponsor and property, whether they share common attributes. They're actually judging the credibility, the genuineness, and authenticity of the relationship itself. So research suggests that consumers judge partnership authenticity through four things: continuity, credibility, integrity, and symbolism. In simple terms, consumers are asking, is there a history behind this sponsorship relationship? Does it deliver what it promises? Does the organization sponsoring the event that I like or the sports team I like appear genuinely committed and interested in their matter? And does the partnership actually mean something to people they're trying to engage? So what does this mean for sponsors? It means authenticity isn't created simply by being associated with an event, a team, or a social initiative. In other words, if you are sponsoring sustainability program, putting your logo next to somebody else's sustainability effort doesn't automatically make the partnership authentic. Authenticity comes from contribution. It comes from rolling up your sleeves and actually doing something, such as reduce waste, improve mobility, or you can develop circular solutions or help solve a genuine community problem. And better still, involve your customers, employees, and communities in that process. That's when sponsorships moves from simple exposure and association to authentic engagement, something people genuinely believe in. Ultimately, authenticity isn't created when sponsorship contract is signed. It's built over time through what an organization consistently does once the partnership begins. And that brings us to the final idea. how do we use sponsorship to build the brand? Most organizations don't have just one sponsorship. They support sports, community, the arts, education, and different charities. The challenge is that these partnerships are often managed separately, but consumers don't necessarily see them that way. From their perspective, all of these partnerships add up to a broader impression of who your organization is and what it stands for. So one question for sponsors to consider is, what story do all of your sponsorships tell collectively? If your partnership consistently reinforces themes such as sustainability, inclusion, or well-being, you are doing much more than generating exposure. You are building a clear and coherent brand identity. And when your activities and engagements bring those values to life, the story becomes even more credible and believable. Nike provides a useful illustration. Its relationship with athletes such as Naomi Osaka, Simone Biles, and Sam Kerr sit within a broader conversations around athlete well-being, mental health, and empowerment. The important lesson isn't simply that individual athlete's endorsement. It's the coherence across the portfolio and the broader brand narrative put together. So the athletes, the partnership, the campaigns, the organizational behavior all reinforce a similar brand narrative. So remember, buying sponsorship rights gives you the platform, but it doesn't guarantee authenticity. Those are earned through how you activate the partnership and demonstrate genuine commitment to what you sponsor and consistently reinforce what your organization stands for. So that's my few minutes of talk. Thank you very much for listening and for inviting me to this session.
Monica, thank you so much. And can you put your email address from your slide into the chat, just so that if anybody wishes to follow up?
Absolutely.
This is so germane to the work we do every year when we review a number of the members' reports under reporting matters, because there is a line item in relation to the role of partnerships. So I'll actually be taking your slides and putting them into the factors and AI, Kasia, for the review for this year. It's really interesting how you've framed that particular conversation there. That's really quite interesting. All right, conscious of time. Are there any questions of Monica before we have to chuff off? No? All right. But if you do have questions, by all means, capture Monica's email address and talk to her directly at the business school. Many thanks. So in wrapping up, thank you again for joining us and contributing today. Particularly thank you, call out to Barbara, to Kasia, and to Monica. We'll be sharing the recording and the relevant follow through in our usual channels, which is YouTube. We'll also have a copy of the YouTube post in ESG Snapshot next Monday, but it'll also go out publicly on LinkedIn as well. Don't forget Landscape returns next week, Wednesday the 26th of August at the new time of 12 p.m. And if you haven't registered or I've required you to re-register, sorry, but it is, and it'll put it into your diary for 12 p.m. And as promised, we'll finish there, hopefully with enough time for you to now get on to the next thing you need to do on your busy days. And as I always say, as closing out, look forward to seeing you all somewhere in the future. Bye for now.
Thanks, Andrew.
Thank you,
Bye.
Andrew.
Thank you, Andrew.
Thank you,
Bye.
everybody.
Thank